Hi, everyone. Harry here to talk about the first judicial decision going in favor of Trump on a significant aspect of his interpretation of the Alien Enemies Act. Okay, we know several judges have emphatically rejected Trump's and the administration's interpretation, which is that the presence of some hundreds or so of members of Tren de Aragua in the United States constitutes a predatory incursion. You need either a war or a predatory incursion. Moreover, a predatory incursion by a foreign government. Courts have had no hesitation in saying that that's completely nuts. And the Supreme Court has made it clear in its own opinion that it falls to courts to determine the meaning of those words. It's not to the administration to say this is a predatory incursion, trust us and go away to the courts. Okay. Enter Judge Stephanie Hayes of the Western District of Pennsylvania. That's my old district. And indeed, of the United States Attorney's Office, my old office in the Western District of Pennsylvania. She's a Trump appointee, having been appointed in 2019 during Trump 1.0. And her opinion is significant in his favor on one element of the interpretation, maybe the craziest one. She allows, and I don't mean to laugh, wipe that smirk off your face, Mr. Littman. She allows that the presence, as the administration says, constitutes a predatory incursion. She has an overall kind of muddled, let me say, it's this is something I know a fair bit about, originalism and the application of constitutional terms to modern day settings. But in her opinion, foreign terrorist organizations, and Tren de Aragua has been so designated by Marco Rubio, are the modern day equivalent of certain, if not countries, then kind of pirates invasions or sort of loose actual invasions in the country. Of course, it has to be by a foreign country under the statute, but she is endorsing the interpretation that these members of a transnational organization can qualify. And she, therefore refuses a preliminary injunction that she is one person before her. She didn't do a broader injunction. She is one person before her. Now, that person, I think in her mind, if you read her opinion, it actually, she sees it as kind of Solomonic or not going all in Trump's direction. And there are important ways where she doesn't. First, she adheres to the idea that it's to the judiciary to interpret what is a predatory incursion. But she then puts a gloss on it that's extremely deferential, essentially saying we cannot question the facts as they present them. Now, of course, the facts as they're presented, it's not, we don't have any kind of long findings or anything like that by administration. It's just a simple assertion that this is a predatory incursion by a foreign government. In other words, their so-called application is pretty much the same as the definition. Is this a predatory incursion by a foreign government? So she somewhat confusingly, I would say, takes to herself and to the judiciary the interpretation, is it a predatory incursion, but then allows us how it might be and defers to the executive. And this is the most troubling part of her opinion. There, it's a partial blank check. Not as much as the administration would want, but still basically it's hands off on whether this is a predatory incursion. Now, I'm not too fussed about it, even though it seems wrong to me, because it's just quite clear there's now a conflict in district courts. This is going to work its way up, be probably decided at the Supreme Court level. Nevertheless, it's a, first blow in Trump's favor on what has struck all other courts as really out there and unsustainable interpretations of the act. Now, Haynes at the same time does a few other things. She's only got one person in front of her, and she says that person must have due process and must have 21 days notice, which is more even than other courts have indicated. We know the detainee only by the initials, but we have the same old, at least allegations of sloppiness by the government. The detainee says, I am not a member of Tren de Aragua. I have, it's again seems to be based on tattoos. And if that's right, it's another real eyesore and scandal of the from the Trump administration doing this so summarily in such an ill-considered fashion. And it's an argument that they cannot have final say about who stays and who goes. But there will be a hearing now in Judge Haynes's courtroom, and the detainee, who's known by his initials ASR, will be able to make the argument, look, I'm not a member of Tren de Aragua. You've got the wrong guy. Tattoos, notwithstanding. So in that sense, she does, Judge Haynes really goes not nearly as far as the Trump administration wants her to do, which is basically to just give them carte blanche. Nevertheless, there's now some judicial authority for the pretty tenuous, to my mind, proposition that the presence of some members of this group in the United States is tantamount to or qualifies under the statute for a predatory incursion by a foreign government, at least if you defer to, basically don't even question, the not the supposed definition of what predatory incursion by a foreign government is, but the application, the actual facts, and the facts as presented by the administration, although it's not really clear at all what they may be. But basically, she's saying, I'll take your word for it. Okay, so that would be quite, I think, bad and transgression of justice if it became the overall law of the federal courts. I see it as very unlikely. It's out of step with it. But it gives rise to a particular case that the Trump administration can point to, and it certainly will. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.